I sat frozen in the courtroom as my former boss's testimony hammered the final nail in my career coffin. "Your non-compete will muzzle you for a year," he testified with a smirk that only I could see. 8 years of expertise rendered useless. 3 months of savings dwindling and 2 children depending on me. When I signed that buried clause, I never imagined becoming unemployable overnight. The judge's pen scratched notes, his expression unreadable. The corporate attorney smiled confidently, unaware that this ordinary Tuesday would upend contract law for me forever. 8 years ago, I walked into Mid-American Healthcare Solutions as a wide-eyed 26-year-old with a fresh analytics degree and determination to prove myself. The healthcare industry fascinated me with its potential to use data to improve patient outcomes. I started as an entry-level analyst, spending countless nights learning every aspect of healthcare data systems. My desk was always the last one with the lights on. I'd wave goodbye to the cleaning staff while refining my reports and creating more efficient processes. That dedication didn't go unnoticed. Within 2 years, I'd received my first promotion to senior analyst, then team lead, and finally department manager overseeing 6 other analysts. "Crystal is our data wizard," my original boss would say during quarterly meetings. "She sees patterns no one else does." I thrived under his mentorship, eventually developing our patient outreach analytics program that increased preventative care compliance by 34%. Life outside work was fulfilling too. My husband Troy and I had 2 beautiful children, Jackson and Emma. We bought a modest 3-bedroom house in a good school district. The future looked secure. Then everything changed. First in my personal life, when Troy and I divorced 2 years ago. The separation was amicable, but I suddenly found myself the primary provider for 2 young children. Jackson was only 5 then, Emma just 3. Child support helped, but the financial responsibility fell heavily on my shoulders. I doubled down on my career, grateful for the stability of my position. The company recognized my contributions with regular bonuses and a comfortable salary that allowed me to maintain our home and provide for my children. Then came the corporate restructuring. A new CEO, Jeffrey Patterson, took over Mid-American with promises of aggressive growth strategies and streamlined operations. Within months, he brought in his own team, including Scott Williams as the new VP of Analytics. From our first meeting, something felt off about Scott. He smiled too widely while his eyes remained cold and calculating. "Impressive work you've done here, Crystal," he said, while scanning my department's performance metrics. "But I see several opportunities for improvement." Those improvements turned out to be taking credit for my innovations while subtly undermining my authority. In meetings, he'd interrupt with phrases like, "What Crystal is trying to say is," or, "That's an interesting approach, but what if we tried something more sophisticated?" I tried adapting to his management style, even as I watched him present my ideas as his own to senior leadership. My team noticed it too. "It's not right how he treats you, Marcus," my senior analyst said after one particularly frustrating meeting. Despite the increasingly hostile work environment, I remained professional, focusing on producing quality work. Then, unexpectedly, an opportunity appeared. A recruiter from Woodland Health Network, a smaller regional competitor, reached out through LinkedIn. "Your reputation in healthcare analytics is outstanding," she said during our call. "We're expanding our data operations and need someone with your expertise." The offer they eventually made took my breath away. 40% salary increase, flexible remote options for better work, life balance with my kids, and a clear path to an executive position. After weeks of interviews and careful consideration, I accepted. I submitted my resignation to Mid-American with the standard 2-week notice, professionally stating I'd received an opportunity I couldn't refuse. Scott's face tightened when he heard the news, though he quickly masked it with a practiced smile. "We'll be sorry to lose you, Crystal. I hope your new position works out well." My final day arrived with the usual exit procedures. The HR director rushed me through paperwork, pausing briefly at one document. "Just a reminder about your non-compete agreement," she said casually. "Standard stuff about not working for direct competitors." I vaguely remembered signing it years ago during my initial onboarding, but hadn't given it much thought. In healthcare analytics, Non-competes were common but rarely enforced except for high-level executives with client relationships. As I was gathering my personal items, Scott appeared at my office door. "I wanted to personally wish you good luck," he said, handing me a company coffee mug as a parting gift. Then, his voice dropped slightly. "I'm sure you understand, Mid-American takes its contractual obligations very seriously. We always protect our investments." Something in his tone sent a chill through me, but I dismissed it as typical corporate posturing. I said my goodbyes to my team, promising to stay in touch, excited about my fresh start at Woodland. That weekend, I reviewed my employment documents to prepare for my new position. Buried in the paperwork was the non-compete clause I'd signed. My stomach dropped as I read the details. It wasn't just about direct competitors, as HR had suggested. It prohibited me from working for any healthcare organization within 3 states for 12 months after leaving. The scope was breathtaking in its overreach, covering even tangentially related positions. I called my friend Tara, who worked in HR at another company. "This seems excessive," I told her. "Can they really enforce something this broad?" "It depends," she said cautiously. "Some judges throw these out if they're too restrictive, but fighting it can be expensive." I tried calming my anxiety. Surely Mid-American wouldn't actually come after a mid-level manager. I had no client relationships, no trade secrets. They had bigger concerns than preventing me from earning a living. I was wrong. 2 days before my scheduled start date at Woodland Health Network, my phone rang. The caller ID showed Amanda Lewis, Woodland's HR director. "Crystal," her normally warm voice sounded strained. "Do you have a few minutes to talk?" My stomach tightened. "Of course, Amanda. Is something wrong?" "I'm afraid there is," she sighed heavily. "Our legal team received a cease and desist letter from Mid-American Healthcare Solutions regarding your employment." I sat down, suddenly lightheaded. "A cease and desist? For what?" "They're citing your non-compete agreement. The letter states they'll pursue immediate legal action against both you and Woodland if we proceed with your employment. They've attached your signed agreement." My mind raced. "But I'm just an analyst. I don't have client relationships or proprietary information." "I know," Amanda said, sympathy evident in her voice. "But our legal team reviewed the document, and unfortunately, the language is quite comprehensive. They're concerned about the potential litigation costs." I understood the subtext immediately. "You're rescinding the offer." Another heavy sigh. "I'm so sorry, Crystal. We really wanted you on our team. If circumstances change or after your non-compete expires, please contact us immediately. You're exactly the kind of talent we need." The call ended with awkward apologies, leaving me stunned in my kitchen. I looked at my children playing in the living room, blissfully unaware that our financial stability had just evaporated. That night, after putting Jackson and Emma to bed, I sat at my dining table with spreadsheets open, calculating how long my savings would last. 3 months of mortgage payments, groceries, and utilities if I was extremely careful. 4, if I dipped into the kids' college fund, which I refused to consider. "It's fine," I told myself. "I'll find something outside healthcare." The next morning, I revamped my resume to emphasize transferable skills and began applying to data analyst positions in other industries. My qualifications were strong, and initial responses seemed promising. Within days, I had interviews scheduled with a retail analytics firm, a financial services company, and a transportation logistics organization. Each interview started enthusiastically. "Your experience is impressive," they'd say, before inevitably asking, "Why are you looking to leave healthcare?" I crafted an honest but positive response about seeking new challenges. The interviews seemed to go well, with discussions about salary expectations and potential start dates. Then, silence. One by one, the promising leads disappeared. Follow-up emails went unanswered or received vague responses about going with another candidate. After 2 weeks of this pattern, I called Tara again. "Something strange is happening. I'm getting to final rounds. Then suddenly nothing." "That is weird," she agreed. "Your skills are in high demand. Data analysts with your experience usually have multiple offers." Another week passed with similar results. My optimism was fading, replaced by growing anxiety. The mortgage payment loomed, and Jackson needed new shoes for school. Tara suggested I consult with an employment attorney. Just to understand your options, she said. The initial consultation is usually free. That's how I found myself in Jessica Thompson's office, surrounded by law books and framed diplomas. She was younger than I expected, but her questions were sharp and insightful. This non-compete is exceptionally broad, she said, frowning at the document. It essentially prevents you from working in your field anywhere in the region. Can they enforce something like that? I asked. Jessica tapped her pen against the desk. Courts are increasingly skeptical of overreaching non-competes, but litigation is expensive and time-consuming. Even winning could take months you can't afford. So I'm just supposed to be unemployed for a year? My voice cracked slightly. There are potential approaches, she said cautiously. We could request a declaratory judgment that the agreement is unenforceable or negotiate a more limited restriction. When she outlined the potential costs, my heart sank. Legal fees would quickly deplete my remaining savings, with no guarantee of success. I left her office with a promise to consider my options, feeling more trapped than before. That evening, checking my email, I found an anonymous message that chilled me to the core. Thought you should know Mid-American is calling every company you interview with. They're threatening legal action against anyone who hires you. Good luck finding work in this state. I stared at the message, my hands shaking. This wasn't just enforcement of a legal agreement, it felt like personal vendetta, and I was beginning to suspect who was behind it. Sleep eluded me that night as I pondered my shrinking options. The walls were closing in, and I had 2 small children depending on me. Something had to give. By the 6-week mark of unemployment, the financial pressure became impossible to ignore. Each morning, I'd wake before dawn, check my dwindling bank account, and feel that familiar knot of anxiety tighten in my chest. The carefully constructed budget I'd created now seemed like a cruel joke. I expanded my job search beyond analytics entirely, applying for administrative positions, customer service roles, anything that might generate income. The responses were consistent. You're overqualified, or worse, no response at all. One particularly humiliating afternoon, I found myself at Valley Mart, applying for a cashier position. The manager, barely older than 25, scanned my resume with raised eyebrows. You were a healthcare analytics manager making. His eyes widened at the salary history I'd foolishly included. Why would you want to work here? I swallowed my pride. I need a job, and I'm willing to work hard. Look, he said, not unkindly. You'd be bored within a week, and I can't pay anywhere near what you're worth. You'd leave as soon as something better came along. I wanted to tell him nothing better was coming along, that I was barred from my profession by an unenforceable contract that no one was willing to challenge. Instead, I thanked him for his time and walked to my car where I finally let the tears flow. That same week, I received a call from Jackson's school. His teacher was concerned about behavioral changes, withdrawn in class, uninterested in activities he usually enjoyed. Has there been any change at home? She asked gently. We're going through some financial adjustments, I admitted. I'm trying to keep things normal for the kids. But children sense tension, regardless of how we try to shield them. That night, I found Jackson sitting on his bed, clutching his piggy bank. Is this enough to help, Mommy? He asked, his 7-year-old face serious with concern. I sat beside him, fighting back tears. That's your money, buddy. Mom's just figuring some things out with work. Everything will be okay. His small arms wrapped around my neck. Dad said you might have to sell the house. My heart sank. Troy had been behind on child support for months, citing his own business struggles. I'd been covering the gap from savings, now nearly depleted. I hadn't told him how dire things had become, but apparently he'd picked up on my growing desperation during our last custody exchange. With Emma's 5th birthday approaching, I faced impossible choices. Cancel the small party I'd planned? Use credit cards I knew I couldn't pay off? Ask my parents for help? Pride finally gave way to necessity. My father answered on the 2nd ring. Crystal, how are my favorite grandkids? They're good, Dad. I paused, the words sticking in my throat. But I need to ask you something. My parents had always been supportive, living modestly on my father's pension and my mother's part-time income. They didn't have much, but they offered what they could, a loan to cover 2 months of mortgage payments. I accepted with a promise to repay every penny. The temporary reprieve gave me breathing room, but not solutions. At Tara's insistence, I agreed to meet my former colleague Marcus for coffee. We chose a spot far from Mid-American's offices, where we were unlikely to encounter current employees. "You look tired," he said bluntly, sliding into the booth. "Unemployment will do that," I attempted a smile. "How are things at the company?" Marcus glanced around before leaning forward. "Scott's been impossible since you left. He's trying to implement your patient outreach program, but it's failing because he doesn't understand the underlying methodology. He could just ask the team. They helped build it. He fired Terry and reassigned everyone else. Claims he's rebuilding from scratch, but it's really your framework with superficial changes." He hesitated. "There's something else you should know. Before you left, Scott was telling executives you were planning to steal clients and proprietary methods." The pieces suddenly clicked into place. He engineered this, I realized. He wanted me gone, but was afraid I'd compete against him. "He's terrified of you, Crystal. Your program makes his entire strategy viable. Without it, he has nothing to show the board. This information should have been validating. Instead, it fueled a helpless anger. Scott was systematically destroying my career to protect his own inadequacy, and I had no recourse. In desperation, I called Mid-American's HR department. The director remembered me and sounded genuinely concerned about my situation. "The non-compete was never intended to prevent employees from working entirely," she said. "Let me speak with legal and see if there's some compromise." Hope flickered briefly until our follow-up call a week later. "I've been authorized to set up a meeting with legal," she said. "They're willing to discuss options." The meeting was scheduled for the following Tuesday at Mid-American's headquarters. I spent hours preparing, researching similar cases, and drafting proposals for a reasonable modification to the agreement. I arrived 15 minutes early, dressed in my best interview suit, clutching a portfolio of carefully prepared documents. The conference room felt intimidatingly familiar, the same one where I'd presented countless analytics reports. 2 attorneys and the HR director greeted me with professional courtesy. They listened to my presentation about the unreasonable scope of the non-compete and its devastating impact on my ability to support my family. "We understand your concerns," the lead attorney said after I finished. "Mid-American values its former employees and has no desire to create undue hardship." Relief washed over me. "I'm glad to hear that. I'm not looking to compete directly. I just need to work in my field." "We have a proposal." He slid a document across the table. "Mid-American is willing to release you from the non-compete restrictions under certain conditions." I eagerly scanned the document, then felt my blood run cold. The certain conditions included signing over all intellectual property rights to the analytics methodologies I'd developed, permanently waiving any claim to recognition or compensation for my innovations, and accepting a 5-year expanded non-disparagement clause. I struggled to maintain composure. "You're asking me to give away my life's work for the privilege of being employable." "We're offering a reasonable compromise," the attorney replied smoothly. "The company has invested considerably in your professional development." I stood up, gathering my materials with shaking hands. "That's not a compromise. That's exploitation." As I left the building, the magnitude of what I was facing finally hit me. This wasn't just about a job or money anymore. It was about my identity, my dignity, and my future. And for the first time, I allowed myself to feel the full force of my rage. The days following the meeting with Mid-American's legal team marked my lowest point. I sat at my kitchen table late at night, researching apartment rentals in distant states where the non-compete couldn't follow me. The thought of uprooting my children, taking them away from their school, friends, and their father made my stomach turn. But what choice did I have? Jackson appeared in the doorway, rubbing his eyes. "Mom, are you coming to bed?" "Soon, sweetie. Go back to sleep." "Are we moving?" he asked, his voice small. My laptop screen reflected in his worried eyes. "Just looking at options," I said, closing the screen. "Nothing decided yet." After tucking him back in, I called Troy, hoping to discuss the possibility of relocating and what it would mean for our custody arrangement. Instead, the call revealed another blow. "I'm sorry, Crystal, but the business is struggling. I can't make the child support payment this month. His voice held genuine regret, but that didn't help my situation. Maybe next month things will pick up. The kids need new winter clothes, Troy. Emma's outgrown everything from last year. I know. I'm trying. Can your parents help again? I ended the call before saying something I'd regret. My parents had already stretched their fixed income to help with the mortgage. I couldn't ask for more. Desperate for any solution, I enrolled in an online coding boot camp, thinking I could pivot to software development. The learning curve was steep, especially while juggling parenting and the ongoing job search, but I pushed through exhaustion, studying late into the night. A glimmer of hope appeared when a small tech startup showed interest in my new skills despite my limited experience. The interview went well. They seemed impressed by my analytics background and eagerness to learn. We need someone who can grow with us, the founder said. Your data experience is actually perfect for what we're building. For the first time in months, I allowed myself to feel optimistic. Then came the familiar pattern. Enthusiastic follow-up, discussion of specifics, then sudden radio silence. After a week of unanswered emails, I received a terse message. After further consideration and background review, we're pursuing other candidates. I knew what background review meant. Somehow, Mid-American was still poisoning the well. The non-compete had become a scarlet letter, visible to every potential employer. Marcus reached out again, suggesting we meet at a park far from any business districts. He looked nervously over his shoulder as he approached my bench. Scott's program launch was a disaster, he said without preamble. The system crashed during the executive demonstration. He blamed the IT department, but everyone knows he modified your algorithms without understanding them. Under different circumstances, this might have felt satisfying. Instead, it just underscored the senselessness of my situation. I was barred from working while my innovations were being butchered. There's something else, Marcus continued, his voice dropping. Scott's been talking to people in the industry about you, saying you were fired for performance issues and ethical concerns. That's slander, I exclaimed. I resigned with notice and perfect performance reviews. I know. Everyone who worked with you knows. But he's VP, and people listen. Marcus hesitated. I'm putting my neck out telling you this, but it's not right what they're doing. That evening, Tara called with a potential lifeline. There's a lawyer you should talk to, Paul Gregory. He specializes in employment law and has taken on cases against major corporations. I can't afford more legal fees, Tara. Just meet with him. First consultation is free. What do you have to lose? Paul Gregory's office was smaller than Jessica Thompson's, the furniture worn but comfortable. He was older, with salt and pepper hair and reading glasses perched on his nose as he reviewed my documents. This is one of the most overreaching non-competes I've seen, he said finally. And I've seen hundreds. Can anything be done? I asked, trying to keep desperation from my voice. He removed his glasses, rubbing the bridge of his nose. It's an uphill battle. Mid-American has resources you don't. Litigation could drag on for months. My heart sank. Another dead end. However, he continued, there are legal vulnerabilities here. The geographic scope is excessive, the duration questionable given your position, and if what you're telling me about their active interference with your employment opportunities is true, we might have grounds for tortious interference. For the first time, I heard someone suggesting my situation wasn't hopeless. Still, the practicalities remained. What would it cost? I asked. His estimate confirmed what I feared. Tens of thousands in legal fees, with no guarantee of success. I wish I could help more, he said, genuinely regretful. These cases are important, but they're David and Goliath battles. I thanked him for his time and left, more discouraged than ever. 3 months unemployed, savings nearly gone, parents tapped out, an ex-husband unreliable. I was running out of options and hope. That night, I received an unexpected email from an address I didn't recognize. The subject line read simply, About Mid-American's non-competes. My name is David Warner, it began. I was Chief Operations Officer at Mid-American until 2 years ago. We've never met, but I heard about your situation through mutual connections. This isn't the first time the company has used non-competes to crush former employees. During my tenure, I objected to this practice and was overruled. I left shortly after. There's a group that might be able to help you. They're called the Workers' Rights Coalition, and they specifically support employees facing predatory contracts. Contact Sarah Livingston at the number below if you're interested. Whatever you decide, don't give up. What they're doing isn't just unfair, it may be illegal. I stared at the message, reading it multiple times to ensure I wasn't imagining things. Could this be legitimate, or was it some kind of trap? After deliberation, I decided I had nothing left to lose. The next morning, I called the number. Sarah Livingston's voice radiated competence and compassion when she answered my call. She listened patiently as I explained my situation, occasionally asking clarifying questions. Your case has several elements that make it particularly strong, she said after I finished. Would you be willing to meet with our legal team? The Workers' Rights Coalition operated from a modest office suite downtown. Their waiting room featured posters highlighting previous victories: farm workers win back wages, retail chain abandons forced arbitration, tech workers defeat restrictive covenants. Sarah greeted me personally, a petite woman with an aura of understated authority. Thank you for coming in, Crystal. Let me introduce you to our team. The conference room contained 3 attorneys, and David Warner himself, the former Mid-American COO who had emailed me. Seeing my surprise, he extended his hand. I apologize for the mysterious approach, he said. Corporate politics required discretion. For the next 2 hours, I shared every detail of my experience while the attorneys took notes. They asked pointed questions about the non-compete, Scott's behavior, and Mid-American's actions to prevent my employment. When I finished, the lead attorney, Michael Rodriguez, summarized their perspective. The agreement itself is problematic, but their active interference with your employment opportunities is potentially actionable. Recent cases have established that non-competes cannot prevent an employee from earning a living in their field of expertise. Sarah explained how the coalition worked. We provide legal support for cases that have potential to create precedent. If you're willing to fight, we can help with resources and pro bono legal representation. What are the chances of winning? I asked. Michael exchanged glances with his colleagues. There are no guarantees in litigation, but we've done preliminary research on Mid-American's enforcement patterns. They've sent hundreds of cease and desist letters, but have never actually taken a non-compete case to trial. They rely on intimidation, David added. Most employees can't afford to fight, so they just comply or change careers. What would I need to do? I asked. It would mean going public, Sarah cautioned. Filing a lawsuit against your former employer is high profile. There could be industry backlash. I'm already blacklisted, I said with a bitter laugh. What more could they do? The decision wasn't easy. Litigation would mean months of stress, public scrutiny, an uncertain outcome. But continuing on my current path guaranteed financial ruin. If I do this, I said finally, I want to make sure it helps others too. This shouldn't happen to anyone else. Sarah smiled. That's exactly why we exist. The coalition connected me with Paul Gregory, the attorney I'd consulted earlier. With their backing, he agreed to take my case, with the coalition covering most expenses. We developed a strategy targeting both the non-compete's enforceability and Mid-American's interference with my employment opportunities. Research became my full-time job. I dug through employment law precedents, industry standards for non-competes, and Mid-American's litigation history. Paul filed requests for company records regarding their enforcement practices. Through the coalition's network, we discovered Scott had faced similar accusations at his previous company, using legal intimidation to sideline potential competitors. This pattern strengthened our case that the non-compete enforcement was not about protecting legitimate business interests, but preventing competition. Preparing for litigation meant making difficult decisions. I withdrew Jackson from his after-school activities and moved Emma to a less expensive daycare. Every penny counted now. The kids noticed the changes, despite my efforts to shield them. Why can't I go to soccer anymore? Jackson asked one evening. We're taking a break for a while, I explained. But Mom's working on something important that might help a lot of people. Are you going to be a superhero? Emma asked with wide eyes. I hugged her tight. Not exactly, sweetie. just someone trying to fix something that's not fair. As we built our case, an unexpected package arrived at Paul's office. It contained printed emails from Mid-American's internal servers, showing Scott specifically discussing how to use the non-compete against me. "We need to neutralize Cristal before she becomes competition," one email read. "The non-compete gives us leverage to keep her innovations in-house." Another email explicitly acknowledged the agreement's questionable enforceability. "Legal says the scope might not hold up in court, but most employees can't afford to challenge it. The threat is usually enough." Paul was cautious. "These are powerful evidence, but we need to verify their authenticity. Using stolen internal communications could backfire." After careful investigation, we confirmed the emails came from a whistleblower still employed at Mid-American. They were willing to testify to their authenticity if needed, though they requested anonymity until trial. With mounting evidence and the coalition's support, we filed suit against Mid-American Healthcare Solutions, challenging the non-compete and seeking damages for their interference with my employment opportunities. The company's response was swift and aggressive. Their legal team filed motions to dismiss, arguing the non-compete was standard industry practice and that I had knowingly agreed to its terms. During this period, I received an unexpected call from Amanda at Woodland Health Network. "We've been following your case," she said. "What you're doing takes courage." "It feels more like desperation," I admitted. "Well, we're rooting for you. And if things go your way, we'd still love to have you join us." That small vote of confidence meant more than she could know. For the first time in months, I allowed myself to imagine a future beyond this fight, a return to meaningful work, financial stability for my family, perhaps even industry change that would protect others from similar experiences. As our court date approached, Mid-American made their first settlement offer. They would narrow the non-compete to direct competitors only, in exchange for dropping all claims. Paul brought the offer to me. "It would solve your immediate employment problem. You could work in healthcare, just not for their direct competitors." I considered it briefly. "And what about the next person they do this to?" "This isn't just about principle," Paul cautioned. "Trials are unpredictable. You could end up with nothing. Or we could set a precedent that helps hundreds of others," I countered. "I've come this far. Let's see it through." The night before trial, I sat with Jackson and Emma, explaining that Mom would be in court for the next few days. "Are you in trouble?" Jackson asked worriedly. "No, honey. I'm standing up for something important. Sometimes adults have to use courts to figure out what's fair. Like when me and Emma fight and you decide who gets the last cookie," he asked. I smiled. "Something like that. But with more lawyers and no cookies." As I tucked them in, Emma wrapped her arms around my neck. "Daddy says you're being brave," she whispered. Those simple words carried me through the sleepless night that followed. Whatever happened in that courtroom, my children would know their mother fought back when it mattered. The morning of the trial dawned clear and cold. I stood on the courthouse steps with Paul, watching Mid-American's legal team arrive in a convoy of black SUVs. 5 attorneys in expensive suits, carrying leather briefcases and exuding confidence. Our side consisted of Paul, one junior attorney from the coalition, and me, clutching a folder of documents with white knuckles. "Remember," Paul said quietly, "they want to intimidate you. That's their primary strategy. Stay calm and stick to the facts." The courtroom itself was smaller than I'd imagined, with wooden benches worn smooth by years of anxious litigants. Judge Robert Caldwell presided, a man in his 60s with piercing blue eyes and a reputation for no-nonsense efficiency. Opening statements set the tone for the battle ahead. Mid-American's lead attorney, Lawrence Bennett, painted me as an opportunistic employee who had accepted the company's investment in my career, only to attempt to leverage that training against them. Mid-American Healthcare Solutions spent 8 years developing Miss Walker's skills and introducing her to proprietary methodologies, Bennett argued smoothly. The non-compete agreement she willingly signed simply protects the company's legitimate business interests from unfair competition. Paul's opening was measured and direct. This case isn't about protecting trade secrets or client relationships. It's about a corporation using excessive legal restrictions to prevent a mid-level analyst from earning a living in her field of expertise. The evidence will show that Mid-American's enforcement of this non-compete goes far beyond protecting legitimate business interests and ventures into anti-competitive territory that violates public policy. The company's witnesses came first. HR directors explaining standard practices, executives discussing the competitive healthcare analytics landscape, and finally Scott Williams himself. Scott looked exactly as I remembered, impeccably dressed, with that same practiced smile that never reached his eyes. He took the stand with the confidence of someone accustomed to being believed. Miss Walker was in a position to access our most sensitive analytical methodologies, he testified. The patient outreach program represents millions in research and development. We simply can't allow that investment to walk out the door to competitors. Bennett guided him through a carefully constructed narrative about my access to proprietary information and the potential harm to Mid-American if I worked for competitors. In your professional opinion, what would be the impact of Miss Walker working for a competitor like Woodland Health Network? Bennett asked. Scott's face hardened. Devastating. She could replicate our systems, approach our clients with insider knowledge of pricing structures, and effectively undermine years of corporate development. And the non-compete agreement? A standard protection. Your non-compete will muzzle you for a year, he testified, looking directly at me. That's a reasonable cooling-off period to protect our intellectual property. During cross-examination, Paul methodically dismantled Scott's expertise claims. He asked detailed technical questions about the patient outreach program that Scott struggled to answer accurately. Mr. Williams, could you explain the statistical methodology used in the predictive modeling component? Paul asked. Scott hesitated. It's a proprietary algorithm developed by our team. Yes. But what specific approach does it use? Regression analysis? Neural networks? Decision trees? I'd have to consult with our technical team for that level of detail. Paul pressed further. The program Miss Walker is allegedly threatening to steal. You can't explain how it actually works? I understand its business application, Scott replied stiffly. The technical implementation is delegated to specialists. Specialists like Miss Walker, who actually built the system you're now claiming as corporate intellectual property? Objection, Bennett interrupted. Argumentativa. Sustained, Judge Caldwell ruled. Rephrase, counselor. Paul shifted tactics. Mr. Williams, when did you join Mid-American Healthcare Solutions? Approximately 14 months ago. And the patient outreach program was implemented when? Scott shifted uncomfortably. 3 years ago, according to company records. So you had no involvement in its development? Not its initial development, no. But I've overseen significant enhancements. Paul introduced performance metrics showing the program's effectiveness had actually declined since Scott took over. The implication was clear. He didn't understand the system he was claiming needed protection from me. As our case progressed, we presented expert witnesses on industry standards for non-competes. Dr. Eleanor Kwan, a respected healthcare policy researcher, testified that the geographic and industry scope of Mid-American's agreement far exceeded typical restrictions. In my 20 years studying healthcare employment contracts, she stated, I've never seen a non-executive restricted from working anywhere in the healthcare sector across 3 states. It's simply excessive. Judge Caldwell seemed particularly interested in this testimony, asking several clarifying questions about standard practices and reasonable limitations. Just as momentum seemed to be shifting in our favor, Bennett announced a surprise witness, Terry Nelson, my former team member who had supposedly been fired after my departure. Terry avoided my eyes as he took the stand. Bennett established his credentials as a senior analyst who had worked under my supervision for 3 years. Mr. Nelson, did Miss Walker download company files prior to her resignation? Bennett asked. My heart stopped. What was happening? Yes, Terry replied. I observed her downloading analytics datasets and methodology documentation in the weeks before she left. And was this unusual behavior? It was. Those files contained proprietary information not typically stored locally. I leaned over to Paul, whispering urgently, That's not true. I only downloaded my personal performance reviews and project summaries I'd created. Paul nodded, making notes for cross-examination. Terry's testimony continued, painting me as someone who had planned to use Mid-American's intellectual property at Woodland, Each statement twisted standard practices into something sinister. By the time Bennett finished, the judge was frowning. During a brief recess, I confronted Paul. Why would Terry lie like that? We were friends. Let me handle this, Paul assured me. There's more happening here. When cross-examination began, Paul established Terry's current position first. Mr. Nelson, what is your current role at Mid-American? Terry straightened his tie. I'm now Director of Analytics Innovation. And when were you promoted to this role? 3 months ago. That would be after Miss Walker's departure and after litigation began, correct? Yes, but the timing is coincidental. Paul approached the witness stand. Mr. Nelson, isn't it true that the position you now hold is essentially the role Scott Williams promised to Miss Walker before bringing in outside leadership? Terry's composure slipped slightly. I wouldn't know what was promised to her. Let me rephrase. You've taken over management of the patient outreach program Miss Walker developed, correct? I'm overseeing its continued development, yes. Paul introduced a series of emails showing that Terry had been specifically selected for promotion after agreeing to testify. In one particularly damning exchange, Scott had written to HR, Nelson will be cooperative. Ensure the promotion is processed before depositions begin. Terry's credibility crumbled under this revelation. By the time Paul finished, it was clear his testimony had been purchased with career advancement. The most dramatic moment came when Judge Caldwell himself began questioning Scott directly about specific language in the non-compete agreement. Mr. Williams, this clause restricting employment in any healthcare-adjacent industry. How do you define that term? The judge asked. Scott fumbled through an explanation that essentially encompassed any data-related position in dozens of industries. And this restriction on utilizing analytical methodologies developed or enhanced during employment, wouldn't that prevent Miss Walker from using general skills acquired during her career? Only proprietary methods specific to our company, Scott insisted. Yet the language makes no such distinction, the judge noted. It appears to restrict use of any methodology she worked with during 8 years of employment. Bennett attempted to intervene, but Judge Caldwell waved him off. I'm trying to understand the practical application of this agreement, counselor. If Miss Walker can't work in healthcare-adjacent industries, or use analytical skills developed during her career, what employment options does your client believe remain available to her? The question hung in the air, unanswered. In that moment, I sensed the tide turning. The final day of trial arrived with a peculiar calm. Whatever the outcome, I had stood up for myself and others facing similar injustice. When Paul told me I would take the stand, a strange confidence replaced my earlier anxiety. Just tell your story, he advised. The facts are on our side. I took the oath and sat facing the courtroom. From this vantage point, I could see not only the judge and attorneys, but also spectators who had come to watch. Members of the Workers' Rights Coalition, former colleagues, and, to my surprise, Amanda from Woodland Health Network. Paul guided me through my employment history, the development of the patient outreach program, and the devastating impact of the non-compete enforcement. I spoke about nights spent studying children's textbooks with my kids, only to continue working on job applications after they went to bed. The mounting bills, the borrowed money, the constant fear of losing our home. What specific trade secrets or client relationships could you have taken to competitors? Paul asked. None, I answered. My role involved creating analytical systems using publicly available healthcare metrics and standard statistical methods. The value was in how these systems were implemented, not secret formulas or proprietary technology. And did you download company files before leaving, as Mr. Nelson testified? I downloaded only my own performance reviews and project summaries I had personally created for my portfolio. This was permitted under company policy for departing employees. Bennett's cross-examination was aggressive, attempting to provoke an emotional response. He questioned my integrity, my understanding of the agreement I'd signed, and my intentions toward Mid-American's intellectual property. Isn't it true you were angry about being passed over for promotion when Mr. Williams joined the company? He pressed. I was disappointed, I acknowledged. But I continued performing my job at the highest level, as my reviews demonstrate. And you decided to work for a direct competitor out of spite? I accepted an opportunity that would allow me to support my family and use my professional skills. There was no spite involved. Throughout the exchange, I maintained composure, answering truthfully without defensiveness. When Bennett had no further questions, Judge Caldwell asked me directly about my current situation. Miss Walker, if this non-compete were enforced as written, what would you do for the remainder of the 1-year period? I met his gaze. Your Honor, I've already depleted my savings. I've borrowed money from my parents who are retired on fixed incomes. My mortgage is 2 months behind. If I can't work in my field, I'll likely lose my home and have to move my children away from their school and their father. The non-compete doesn't just restrict my employment, it's destroying my family's stability. After my testimony, both sides presented closing arguments. Bennett emphasized contract law and Mid-American's right to protect its business interests. Paul focused on the human impact and the legal limitations on restrictive covenants. The question before this court, Paul concluded, is not whether non-competes can ever be valid. It's whether this specific agreement, as enforced against this specific employee, violates public policy by preventing her from using her general skills to earn a living. We believe the evidence clearly shows it does. Judge Caldwell announced he would review the evidence and deliver his ruling after lunch. Those 2 hours were the longest of my life. I sat with Paul in a small conference room, neither of us saying much. Whatever happens, I told him finally, thank you for fighting for me. He smiled. You're the one who refused to give up. That's rarer than you might think. When we returned to the courtroom, Judge Caldwell entered with an unusual request. Before I deliver my ruling, I'd like the clerk to bring me the statute books for Section 46. He adjusted his glasses, flipping through pages until he found what he was looking for. Section 46.11, on restrictive covenants in employment contracts. Very interesting reading. He looked up at both legal teams. This case presents a clear example of a non-compete that extends far beyond what's necessary to protect legitimate business interests. He turned to face Mid-American's side. The evidence shows a pattern of using these agreements not to protect trade secrets or client relationships, but to prevent competition and retain control over employees' livelihoods. Then came the 5 words that would change everything. This contract violates public policy. The judge reached for his notepad, scribbled something, then slid the note to Mid-American's attorney. I couldn't see what he'd written, but Bennett's face flushed as he read it. Therefore, Judge Caldwell continued, I find the non-compete agreement between Mid-American Healthcare Solutions and Crystal Walker to be unenforceable in its entirety. Rather than attempting to modify an agreement that was designed to be overreaching, this court declares the entire restrictive covenant void. He looked directly at me. Miss Walker is free to seek employment in her field without restriction. Furthermore, the court finds that Mid-American engaged in tortious interference with Miss Walker's employment opportunities and awards damages in the amount of her lost wages plus legal fees. The ruling continued with specific findings and technical legal language, but those initial words had already lifted the weight from my shoulders. I was free. The professional prison that had confined me for months had just been unlocked. As we left the courthouse, Paul showed me what the judge had written on that note passed to Mid-American's attorney. Overreach invalidates entirety. 2 simple words with profound implications. Not only had the judge invalidated my specific non-compete, but his published opinion would create precedent for others fighting similar battles. News of the ruling spread quickly through professional networks. By evening, my phone was buzzing with messages from recruiters and former colleagues. Amanda from Woodland Health Network called personally. Our offer still stands, she said. In fact, we'd like to increase it. Your expertise is exactly what we need, and your courage in challenging this practice makes you even more valuable to us. The Workers' Rights Coalition asked if I would share my experience at their upcoming conference. Your case will help us advocate for legislative reform on non-competes, Sarah explained. As weeks passed, my life transformed. I accepted the position with Woodland, but with an unexpected twist. Rather than joining as an employee, I established my own consulting firm specializing in ethical healthcare analytics. Woodland became my first client, with others quickly following. The financial damages awarded covered my accumulated debts and provided stability during the transition. More importantly, the case created legal precedent that the coalition used to help others facing similar situations. Mid-American, facing public scrutiny and potential regulatory attention, announced a review of their employment practices. One evening, as Jackson and Emma helped me unpack boxes in our home, the same home we had nearly lost, Jackson asked a question that stopped me in my tracks. "Mom, why did you fight those people when everyone said you would lose?" I sat down with them on the half-unpacked living room floor. Because sometimes fighting against something wrong is important, even when it's hard. Those people were using unfair rules to stop me from working. "Like when Timmy makes up new rules in the middle of games?" Emma asked, referencing a playground dispute she'd recently experienced. "Something like that," I smiled. "But also because I wanted to make sure other people wouldn't face the same problem." "Did you win because you're smart?" Jackson wanted to know. "I won because I didn't give up, and because good people helped me. Sometimes that's more important than being the smartest or strongest." 6 months after the trial, I stood at a podium addressing a conference of healthcare professionals. My presentation covered ethical data practices and employee advocacy, drawing directly from my experience. "What began as a fight for my own career became something much larger," I told the audience. "It revealed how vulnerable we all are to systems designed to limit mobility and opportunity. But it also showed me the power of persistence and collective action." In the audience sat several former Mid-American employees who had faced similar restrictions. They had reached out after my case made headlines, sharing stories of careers derailed and opportunities lost. Together, we had formed an informal network supporting others navigating restrictive employment practices. The most surprising development came when I received an email from Terry Nelson. "I'm sorry for what happened in court," he wrote. "Scott promised me the promotion would only come through if I testified against you. I've regretted it every day since." I thought carefully before responding. "We all make choices under pressure. What matters is what you do next." 2 weeks later, Terry provided a sworn affidavit detailing Scott's instructions to misrepresent events, which the coalition added to their growing body of evidence for regulatory reform. The journey from desperate unemployment to professional reinvention taught me lessons no career could have provided. I learned that systems of power depend on our silent compliance, that courage often comes from having no alternatives, and that fighting for yourself can create change far beyond your own circumstances. As I build my consulting practice today, I maintain one non-negotiable policy: no restrictive covenants in any contracts. My team members are free to grow, learn, and even leave if better opportunities arise. This approach hasn't weakened our company. It's attracted the most talented and committed professionals who value autonomy alongside security. That ordinary Tuesday in court did indeed upend contract law for me forever, but not in the way I had feared. Instead of ending my career, it launched a new chapter built on principles of fairness and ethical business practices that I now share with others. Have you ever faced a moment when standing up against injustice seemed impossible? What gave you the courage to fight back, or what held you back? Your experiences matter, and sharing them helps others facing similar challenges. Please comment below with your story. Like this video if it resonated with you, subscribe to hear more stories of resilience and justice, and share with anyone who might be struggling against unfair practices in their workplace. Thank you for listening to my journey, and remember that sometimes the battles that seem most hopeless are the ones most worth fighting.